Hi, this is attorney Cedra Vitale. Today's date is 8 February 2017. I am an immigration attorney in private practice in the Boston area. This video is to talk about a new lawsuit brought by the cities of Chelsea and Lawrence, Massachusetts against the administration for the threat to withhold federal funding from so-called sanctuary jurisdictions. One of the things that the complaint points out is that the definition of sanctuary jurisdiction is really quite vague. The other is that it refers to willful refusal to comply with a particular statutory provision, 8 U.S.C. 1373, which requires that no state or local government can interfere in data flow, basically, about a person's immigration status between that state or local official and the federal immigration authorities. There's no requirement that state or local law enforcement collect information about persons' immigration status. And both Chelsea and Lawrence have implemented policies in slightly different ways. They have implemented policies in order to protect their entire populace and encourage trust and reliance on their law enforcement officers, especially the police department. They don't collect immigration status information. That's not, the city's claim, a willful refusal to comply with the dictates of 8 U.S.C. 1373. They're not getting in the way of data flow, they're not collecting any data, and that's not the same thing. So one, they're arguing we could be classified as sanctuary jurisdictions, but we're not sure, and that vagueness is a problem. Two, they're arguing we're not sanctuary jurisdictions because we are in compliance with this statute. And then, much more importantly, they're arguing that the threat to withhold federal funds is unconstitutional under the 10th Amendment, which has to do with the difference between federal and state rights and authorities. The 10th Amendment is the thing that gives states power to do stuff and is recognized in the Constitution, that the states have powers to do things that are not expressly reserved to the federal government. So here we have states making decisions about their law enforcement procedure that's directing basically the federal government to threaten to withhold funds in order to manipulate those policies and procedures. And they say that that is, an untenable invasion of their power and is therefore a violation of the 10th Amendment. So the 10th Amendment argument, I think, is pretty strong. We'll see what happens with the case. I think that, everyone filing complaints about these orders is, among other things, horning in on the ignorance that the orders themselves demonstrate about the new executive's understanding of the law. The lack of coordination, the lack of consultation with legal authorities in order to how to do stuff properly. There's a lot of things that the president does have power to do. General Purcell said during yesterday's argument to the Ninth Circuit Court of Appeals, you can do something and intend to discriminate and that makes it wrong. You can do it with a different intent and then it's not necessarily wrong. I'm paraphrasing a little bit. I think he said it far more eloquently than I did. So that's where things stand at the moment. We are waiting for the Ninth Circuit's decision on the state of Washington case. The appeal was argued yesterday, and while we wait, other cases are going forward and new cases like this one are being filed. Thank you.